Lean in, sir.
Judge, it looks like he's still muted. Little red mics there.
Oh, you are muted. Madam Clerk?
Yep. Yes, sir. Deputy on the 6th floor hallway. Thank you. All right. What's your name, please? Gonzalo Dickerson?
Yes.
Calling case 230-600-5101, people of the state of Michigan versus Wanzel Dewan Dickerson. Defendant is charged with count 1, robbery armed, count 2, larceny from the person, count 3, larceny in a building, count 4, assault with dangerous weapons, felonious assault, count 5, weapons felony firearm. Also count 6, 7, and 8. Today is the date time for a bond redetermination hearing.
Judge, good morning. Steve Vincent for the people.
And good morning, Your Honor. Sydney Rushing, P78830. On behalf of Mr. Dickerson and on behalf of the Misdemeanor and Felony Defender Office, Mr. Dickerson, can you please state your name for the record?
Dewan Dickerson.
Thank you. Your Honor, today is the date and time set for a redetermination hearing. Mr. Dickerson's bond is currently set at $100,000 cash surety. Mr. Dickerson works at Amazon, so he is currently employed, Your Honor. It does have another matter that is pending before the court, and on that matter, I believe it's an armed robbery charge as well. However, Your Honor, he is given a personal bond on that matter. So I'm not sure the facts, obviously, but there's something there that, shockingly, there's a personal bond. Your Honor, I do believe the $100,000 cash surety is an excessive bond. It's one that my client can't post. So we're asking for a reduction.
Mr. Prosecutor.
Nothing shocking about it. From time to time, Judge, we have magistrates who issue personal bonds on cases that the people, request cash bonds on. It was $120,000. He ended up getting a tether and house arrest. And then we have a defendant, while he's on house arrest, while there's an individual coming to his house allegedly to sell him something, at gunpoint ends up robbing that individual. Maybe with all the counterfeit money that was found in his house. Judge, I ended up actually having a discussion with Magistrate Boyer about this. I don't believe the people, this wasn't my case, I don't believe the people brought up remand. But under 6.106, I think it's 2.1b, something to that effect, Judge, remand was possible in this matter. He only ended up getting $100,000 cash assured. We have a defendant who's being charged with armed robbery in a different case, allegedly robbing an individual in this case where he was positively ID'd, where he had a gun, asking the individual for all of his belongings. Quite honestly, Judge, I mean, I could ask for more. I don't know if Your Honor would entertain that. But with that being said, at the very least, we would just respectfully ask Your Honor to continue this one.
Ms. Rush.
Your Honor, just again, Your Honor, that my client, these are mere allegations, and Your Honor, I told you he had another case, and in that case, he was given a personal bond. We're just asking for either a 10% provision or a reduction of the $100,000 cash assured.
See and the incident, just to make sure I'm clear, where's the location of the incident?
At his house, where he lives.
Okay. Huh.
Yeah.
See that makes things a little dicey, Miss Russian. I'm sorry. All right, court haven't heard the arguments of counsel. Court finds that the $100,000 cash bond is an unaffordable bond. To have an unaffordable bond, the court must have a showing of danger to the community or danger to the complaining witness or flight risk. I have to admit, in doing this, being on the bench for 13 years, I've never heard of a defendant allegedly committing a crime while on house arrest at their house. I have to say this is pretty creative. So allegedly, instead of going or meeting someone at a location to sell some products or byproducts to rob them. I'm going to have them come to my house because I'm going to abide by my tether provision by not leaving the house, but I'm going to rob them at my house. I'm in compliance with my tether requirement, but I'm going to possibly commit about 8 felonies while on house arrest at my house with someone who knows me. So, Mr. Dickerson, it's not a lot of deductive reasoning or wise thought put your hand down, being put into this situation. I don't think you want to speak at this time, sir. I think you want to rely on the wise counsel and the zealous advocacy that your lawyer has put in. Because I don't think you want to put a lot on the record, because not a lot that I think can help you at this stage. Maybe testifying at the preliminary exam or possibly at a trial if it gets bound over. That might be in your best interest, but I would recommend that you probably not say anything right now. The issue is, if I wanted to lower the bond, how can I lower a bond and have him stay at home? Because that's where the allegation happens. So you are putting yourself, Mr. Dickerson, in a position where a remand would be appropriate, because the only place that it looks like we can protect the community is to have you incapacitated so that you physically cannot commit a crime on the public. The only crime that you would be able to commit would be on someone that's in the population with you inside the Wayne County Jail. It's my understanding that you're still a teenager, and that you're making some real adult decisions right now as a teenager. Multiple felonies, multiple armed robberies. Armed robbery cases are life offenses where you can never get out of prison. Never. Not sure what's going on with you. Not sure whether you need some counseling to occur while you're incarcerated, but you have forfeited the right to be out. You don't get a chance to go back home and be on house arrest. So what I would recommend, sir, during the pendency of this case and the other armed robbery that you're on, that you may spend some time maybe in meditation, maybe getting some books, some self-help books, or maybe asking the jail if there's any counseling that can be provided to you. Because what you're doing is you're taking your own life away, because you're putting yourself in a situation where you'll never see sunshine again, and you'll have roommates that you don't necessarily want to have for the rest of your life as a teenager. So, with all that being said, Mr. Dickerson, court finds that the $100,000 cash bond is an unaffordable bond. Court finds that the $100,000 cash bond is an appropriate bond based on you being a threat to the community and a threat to the complaining witness. You have forfeited the right to have home arrest because allegedly you committed multiple felonies at that house. So what we're going to do, Mr. Dickerson, to ensure I'm going to give you an unaffordable bond to ensure that you are incapacitated during the tenancy of this case. And this bond is not a punishment. This bond is a bond to make sure that you cannot commit another crime while these cases where you cannot be alleged to commit a crime while these cases are moving. So, because these are all mere allegations, you are innocent till proven guilty. So the $100,000 unaffordable bond is being changed. The bond is being changed to $500,000 cash, no surety. And if you get out, if you post $500,000, you will be on house arrest again. And there'll be the only condition of your house arrest will be for court appearances only. Again, young man, I hope that during this time that these cases are matriculating through the court system, that you spend some time reflecting on why are you in front of the court system so much? Why are you being accused of these crimes? What decisions you're making? Because you're only 19, you got a long life ahead of you. But that long life ahead of you is in peril right now if you don't start making some better choices. So good luck, young man.
Thank you so much, Your Honor.
All right.
And Your Honor, I believe that completes our docket.
All right.
Your Honor,
yes.
We have another case, sir. I'm not sure what docket she has, but we do have Clifton Walker, Your Honor.
Okay, let's see.
And so let me see if they're going to be appearing from the 6th floor hallway, sir, and then that will complete the docket.
Oh, I did miss that.
Sir, state your name for the record.
I'm Clifton Walker.
Okay, call it.
Calling case 230-600-5501, people of the state of Michigan versus Clifton Bernard Walker. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault, count 2, domestic violence, second offense notice. Defendant is labeled as a habitual offender, fourth offense notice. Today is the date and time for a bond redetermination hearing.
Thanks, Judge. Always a privilege. Steve Benson for the people.
And good morning, Your Honor. Sydney Rushing, P78830, appearing on behalf of Mr. Walker. Mr. Walker, can you please state your name for the record?
Clifton Bernard Walker.
Thank you.
Welcome.
1 second.
Your Honor, Mr. Walker's bond is $50,000, 10%.
Okay. Argument.
Your Honor, at this time, we're requesting Your Honor to consider a reduction in Mr. Walker's bond. His bond is currently $50,000, 10%. There is a 10% provision. However, Mr. Walker cannot post that. Your Honor, we're asking for the reduction, and we ask that you consider reducing it.
Prosecute.
Judges, there's no 10% with all due respect.
I didn't see a 10%.
Yeah.
Oh, oh man.
It's okay. It's okay, Ms. Rushing. It's your
Yeah,
first.
no,
First
it's not.
day. It's okay. We got you. We got you.
50,000. I apologize, Judge. I was looking at the wrong ROA.
You're good. Continue, Mr. Prosecutor.
Judge, if and I'm going to be brief, but if you would just indulge me for a couple of brief seconds here. Your Honor, everybody's got a place in life. Your Honor is in the perfect spot, being the chief judge of this courthouse. Your Honor has a great Madam Clerk. She's exactly where she should be. Madam Court Reporter is great at what she does, taking down all of my verbosity on a daily basis.
Correct.
We've never had an incident in this courthouse as a direct result of Officer Ashland, who holds it down. Arguably, I'm not the best person for this spot, but I'm not going to go there. In talking about spots, Judge, this defendant temporarily, his spot should be in jail and long-term should be in prison. That's where he belongs. That's where his spot is. Your Honor, this particular defendant, over the course of the last 30 years, has accumulated what I thought to be 8 different felony convictions, starting out with CSC, and now, most recently, a domestic violence third to a pregnant individual that he was on probation for until October of 2022. The reason why that date is ironic is because he has an ongoing misdemeanor case for misdemeanor that occurred prior to the end of his probation for his DV third. And then, Judge, he ends up picking up this case, and we all know the allegations, but it doesn't stop there. He has 3 more cases that he was supposed to be arraigned on yesterday, but he wasn't with the DDC because he was in jail for this redetermination. He's going to get arraigned on those 3 cases. And what do those 3 cases involve? DV and felonious assault. And who is it with? The complaining witness. The same complaining witness in this case. The same complaining witness in the ongoing misdemeanor case. This shouldn't have been a DV third charge. This could be like a DV 6 because he was actually already convicted of a DV third. So everybody's got their spot, Your Honor. This defendant is perfect where he's at right now. And again, long-term, he's a danger. And dangerous people belong in jail and then in prison. And Judge, respectfully, we're asking you to continue that $50,000 cash bond.
Ms. Rushing?
May I speak, Your Honor?
Well, you can. I would just say this, sir. Anything you say can and will be used against you. Seems like you have a lot of cases pending, and this case is going to move forward. So if you would like to address anything, you may, but just know that your lawyer has argued for you. She's shaking her head saying you should remain quiet, but you have a right to talk if you want.
Mr. Honor, my name is Clifton Walker. I've been home, I did 17 years. I've been home since 2004. I have no other cases except from this particular lady. She has some serious, both of us have some serious mental proclivities. And every time I reach for her, she lies and puts a case on me. I haven't done anything, even though there are so many cases. She has so many. There's 16 cases that she just put on me that have nothing to do with nothing. It's 16, and as we go along in trial, you'll find that out. But I haven't done anything to this lady. I'm not going to do anything to this lady. I'm innocent of all of these charges. I haven't done anything.
And Mr. Walker, thank you for your statement. I'm gonna give you some advice. Okay. I'm not giving you any legal advice because I'm not an advocate, I'm not a lawyer. I'm gonna just give you some advice as a human being, as a man. If there is a woman that has lied on you, and as you just stated, put 16 cases on you, you know what you should probably do? Not be around that woman. Okay, you're not a child. You're not an infant. You're not someone that has to stay in the custody of their mother so they can take to school and get to their pediatrician and make sure they have dental appointments. You are a grown man. If there is a woman that is lying on you, that is keeping you incarcerated and keeping you go through the criminal justice, what you should do is get yourself an apartment, condo, maybe a house, townhouse, a loft, flat, whatever you need to do, and you move into that place. You furnish that place. You get a job. You work. You put food on your own table. And then you know what you wouldn't have is you wouldn't have any dealings with someone who's lying on you and manipulating the criminal justice system. So what I would recommend, sir, is that this should be a wake-up call. I guess the first 15 cases that you're saying she lied on you wasn't a wake-up call. But maybe you should do something a little different. You know, I'm not going to give you the Einstein definition of insanity, but it just doesn't make a lot of sense if someone is keeping me in prison, and I'm not in prison, in jail, and lying on me. And you know, and then you're accusing her of infidelity, and then the cheating is causing the screwdrivers and the violence and the, you know, and the mayhem. This is ridiculous. So with all that being said, sir, court finds that the $50,000 cash bond is an unaffordable bond. Court finds that in order to keep little mute action, Madam Clerk. Red button. Thank you. In order to keep a cash bond, it must be by clear and convincing evidence that the defendant poses a threat to the complaining witness or a threat to the community. Now, with the fact that we're going to spend some time together next week for 3 more cases, we're here now, criminal history. Court finds that, you know, you pose a threat to the complaining witness right now. Again, all mere allegations, innocent until proven guilty. But enough's enough, sir. And the bond will be reduced from $50,000 to $50,000, 10%. Ms. Rushing was reading my mind. Once you get out, we'll have a GPS tether. You'll have a curfew of 10 p.m. to 6 a.m. and a no contact provision with the complaining witness. Mr. Walker, stay away from the person who's the complaining witness. Because if you have contact, you're going to violate your bond, and your bond will be revoked, and then you'll just stay in jail till the rest of your cases are over. So, sir, good luck making some better decisions. Good luck. Good luck, sir, because seems that you need to also, do a little reflection. Do a little reflection and figure out, why do I keep finding myself being arraigned, 4 times in a week? It's not
Thank you so much.
It's not normal. It's not normal to get arraigned 4 times in a week. So try to do something differently and have a good holiday, sir.
Thank you so much, Judge.
You're welcome.